Facebook Live or the YouTube recording of this training. I'm Ann Milligan, the 2020 president of Queen's Bench. And for those joining us that are new today, Queen's Bench meets the second Tuesday of every month at noon. And our speaker series this year is online, free, and open to all. Next month, we're going to be returning to our difficult decisions programming, examining difficult legal decisions from the perspective of the judges who made them. Our speaker next month will be retired immigration judge Andrea Sloan, who will discuss the current crisis in the immigration courts. Every judge faces difficult decisions, but for immigration judges who are employees of the U.S. Department of Justice rather than lifetime or term appointees or electeds, the decisional process is interrupted and informed by unique complications ranging from high case quotas, waning decisional independence, DOJ policy directives, and the complex vicarious trauma that comes from hearing petitioners' stories of rape, genocide, religious, and political persecution. Today, we are here for a special Know Your Rights training along with an introduction to legal observing presented by the American Civil Liberties Union of Oregon. The ACLU of Oregon is an advocacy organization dedicated to defending and advancing civil liberties and civil rights through work in the courts, in the legislature, and in communities. With us today is Kelly Simon, the Interim Legal Director for ACLU of Oregon. She has served in that role since September 2019. Prior to becoming Interim Legal Director, Kelly was a staff attorney and legal fellow for ACLU of Oregon. She holds a JD from WashU in St. Louis and a BA in Theology and Peace Studies from Notre Dame. Her entire legal career has been dedicated to the advancement of civil rights. Please ask any questions that you have throughout this presentation in the chat box function. We will get them at the end of the presentation. Please be sure to check out the supplemental materials for this conversation on our website. You will want to take a look at those. That is owlsqueensbench.org. Kelly, take it away.
Thank you so much, Anne, and thank you to OWLS and especially the Multnomah chapter, Queen's Bench, for having me here today. I think this is such an important topic and important information to be disseminating right now, and so I just thank you for the opportunity to do so. As Anne said, my name is Kelly Simon. I use she, her pronouns, and I am Interim Legal Director at the ACLU of Oregon. ACLU of Oregon has over 30,000 supporters and members throughout the state of Oregon. And we also run a really robust legal observing program, both related to immigration enforcement and police response to protests throughout the state. Our protest program is right now very focused on Portland. It's a newer program, so we haven't quite expanded, but I'm told that hopefully there are folks on the call today who aren't just from Portland, but are spread out throughout the state, and so that we can begin to network and grow these mechanisms of observation throughout Oregon. ACLU of Oregon has also been involved in several pieces of litigation involving protester rights. I think it's safe to say, even though I've only been at the organization for about 5 years, I think it's safe to say we have protest-related cases from every administration dating back to the founding of our organization here in Oregon. We also currently, in the last few years, I should say, have filed 8 pieces of litigation against the city of Portland in particular, related to their use of force against protesters and arrest practices against protesters. So while I know there are folks on the call or on the webinar who are from other places in Portland, a lot of my knowledge is Portland centric. A lot of my examples are from Portland. I apologize for that ahead of time, and encourage you to reach out to ACLU of Oregon if you have questions about particular policies or directives that aren't Portland specific. Before I get started, I just want to give a quick disclaimer. This is not legal advice that I'm giving you today. This is general Know Your Rights information. And if you have questions about your rights in a specific situation, I encourage you again to reach out to us, and I'll provide that contact information later. Unfortunately, I also have to give the disclaimer that it's also not safety advice. I think there's a different calculus around asserting your rights versus protecting your safety. Unfortunately, we know that a lot of vindication of rights happens after the fact, and so I think that is a personal decision that I would encourage you to consider throughout all of this, is thinking through what are the safety implications of asserting your rights in certain situations. Really quickly, just to give everyone an overview, I have about 7 categories of information that I want to talk through. Everything is going to need to be high level since we only have an hour today, and I want to leave time for questions at the end. But to give you an overview, I just want to start with some basic speech rights information. Second, I want to talk about crowd dispersal and the authority to disperse police authority to disperse crowds. Talking about your rights if you're detained or arrested. Talking about particular types of crimes that are often charged when folks who are protesting are arrested. Things like interfering with a peace officer, disorderly conduct. Fifth, I want to talk to you about excessive force. Then talking about observing and documenting what you're seeing. And finally, I want to speak specifically to white folks who may be going out and protesting about etiquette at protests that are about Black Lives Matter, and how to decenter whiteness and what organizations you might look to learn from and lift up their messages, voices, and advocacy. Okay, so starting with general speech rights. Your speech rights are strongest. This may remind you of the bar exam. I apologize if that gives you bad flashbacks, but speech rights are strongest in traditional public forums. So when you hear that phrase, traditional public forums, think streets, sidewalks, parks. Those are the kind of places where our rights are most to speak up, to dissent, to speak out, are most protected, as opposed to on private property, where private property owners have the ability to put conditions on our speech, make rules about our speech. I think where a really interesting question comes are in places like malls that have large parking lots and look like really traditional public forum. They might have sidewalks, and how do our rights apply in those contexts? Fortunately, in Oregon, we have a really speech protective constitutional provision in Article 1, Section 8. There have been some cases that involve leafleting that have protected private property owners' rights at places like Fred Meyer, but in doing so have distinguished places like the Clackamas Town Center. So I think that while we don't have a clear answer on some of those, the more it looks like Clackamas Town Center, I think the more likely one might have constitutional rights, speech rights that are protected versus Fred Meyer. You also have the right to have your message heard. We see this right come up in situations where there are counter protests and law enforcement wants to keep those protesters or protest groups apart. Law enforcement certainly can keep those groups separate, but they can't be so separate that the counter protesters aren't heard by the folks that they're counter protesting, or the protesters aren't heard by the opposing group. Or we see this come up when perhaps a state fair or something is creating speech zones, and if those speech zones are so far removed from where people coming to the fair might hear it, then we have those types of rights implications. The police response to protesters in traditional public forums must be content and viewpoint neutral. This is especially important to think about in context of groups who are counter-protesting each other. I don't know if folks remember the series of protests that Portland has seen. There was one on June 4th, for example, in 2017, where there were several groups of protesters that were kept separate and folks had concerns about the way police were facing one group and not had their backs to another. We've also seen concerns about that when police are shutting down bridges to certain types of regular protest groups and not allowing other types of regular protest groups cross those bridges with police protection. So police really need to treat all groups equally and not selectively enforce their regulations. Another example we saw in Salem recently, there was a video of an officer in Salem telling a couple of known Proud Boys members to stand in doorways so they are out of sight during the curfew. And it doesn't look like there is selective enforcement happening. So again, police must be content and viewpoint neutral. You don't need a permit to protest. And I'm going to say that one more time. You do not need a permit to protest. Police do have more authority to direct the safe flow of vehicular and pedestrian traffic if you don't have a permit, but it is not true that you need a permit to protest. Finally, in general speech rights, you have the right to film the police and film what is in plain view. So public buildings, things like that. You have a First Amendment right to film what is in plain view. In various states, that the audio portion of that may get different treatment, but in Oregon, Oregon has a statute that allows folks to openly record law enforcement performing their duties in public. So there's a very explicit right here in Oregon to openly film law enforcement. Moving on to crowd dispersal, I think that if you're following some of the current protest stories, you'll often see or hear video of orders to disperse, ordering crowds to disperse, even when those crowds are, as the law enforcement has described, largely peaceful. So there's a statute here in Oregon, it's ORS 131.675, that allows law enforcement to disperse 5 or more people who are, the language is unlawfully or riotously gathered. And that's not the direct language, but those two words, unlawfully and riotous assemblies, are from that statute. What gives concern again here is selective enforcement. Is the crowd actually engaged in unlawful or riotous behavior? I think those are questions that we often ask when we have our legal observers out and are hearing those orders. I think there's a lot of room for interpretation in these statutes that I find concerning. If you are out at a protest and you do hear an order to disperse, you have a right to hear that information clearly. So it's important to note and hold law enforcement accountable for making sure people can hear and understand those announcements. And you also need to be given a meaningful opportunity to leave. Sometimes we see this and sometimes we don't. To give another example, in Portland, again on June 4th, there was, when there were several groups gathered, one group was told to disperse to the north. When that group walked north, they were then kettled or surrounded by law enforcement and detained, and not given a meaningful opportunity to leave. More recently, we've also heard kind of inconsistent messages coming at times. So sometimes the announcement is leave the area to the west. Sometimes the announcement is all of downtown is closed. Depending on which part of the crowd you're in, you may hear one or the other of those announcements. So again, you have the right to clear direction and a meaningful opportunity to leave. If you are detained or arrested, I think an important first question you can ask is if you're engaged directly with law enforcement, are you detaining me or am I free to go? And I really encourage you to ask that question, because if you're free to go, you are free to go and you can walk away. Again, this is not safety advice, this is advice about your rights. So there's always a consideration there if it really does feel safe for you to leave. But I think asking that explicit question then puts the ball back in the law enforcement's court to be very clear if you're being detained or not. To detain you, law enforcement needs reasonable suspicion to do so. That means they have to have specific and articulable facts about what suspicion they have of your engagement in criminal activity or your imminent engagement in criminal activity. If you are being arrested, that amount of information or suspicion rises to the level of probable cause. If you're detained or arrested, remember this: you have the right to remain silent. I think since I'm assuming most folks on this call are lawyers, I often think we like to talk and think that since we're lawyers, we know what we're talking about. But I strongly encourage you, even as lawyers, to exercise your right to remain silent. Again, things that you can say can be used against you, and you never know how that might be twisted and used against you. So you do have the right to remain silent. You also have the right to an attorney of your own. So if you're getting asked questions or even being encouraged to engage in small talk while being detained or arrested, I think it's a good time to say, I'd like to exercise my right to remain silent and speak with an attorney. And please do not sign anything without first speaking to an attorney, and in particular, a criminal defense attorney. Questions have come up not as often in the protest context, but in other kind of engagement with law enforcement in the streets context, about whether you're required to provide identification or identify yourself when asked by law enforcement. If you are walking in the streets or marching in the streets, you do not have a legal obligation to identify yourselves. The one area where Oregon law does require you to produce your identification is if you're driving a car and you're pulled over for a vehicular infraction or citation. That does not apply if you're a passenger in the car. So if you are a driver of a car, yes, you do need to produce your ID. If you're walking on a street and police engage you, you do not have to identify yourself. Sometimes if you're being detained or arrested, I should say, if you're being arrested, it may be more expedient for you to identify yourself, because at that point, law enforcement can hold you until they ID you. But if you're not being detained or arrested, you certainly do not have to identify yourself to law enforcement. You also have the right to refuse consent to searches. There are exceptions to the right to refuse consent to searches. If law enforcement believes you may have a weapon and you're being detained, they can stop and frisk the outside of your clothing. If you are arrested, they can search kind of your person and things within kind of your arm's reach if that is incident to an arrest. This is a really important note, though, about the searches incident to arrest. It does not include the contents of your cell phone. So if law enforcement wants to see what is on your cell phone, they need to get a warrant. You are also not required to provide your passcode to law enforcement. These are parts of your Fifth Amendment privileges against self-incrimination. So again, you don't have to open your iPhone or smartphone to let law enforcement look at what's on there. They also cannot destroy, if for some reason they do get access, they cannot destroy, destroy contents of your cell phone. You also have a right to make a phone call if you are taken to jail. One thing I would be mindful of is that all of those calls are recorded. And if you aren't speaking to your attorney, they aren't protected recordings. Real quick, if you do plan to protest in Portland, I want to give you a phone number to write down. This is the National Lawyers Guild's jail support hotline. The National Lawyers Guild has, for much longer than the ACLU, in fact, in Oregon, had a well-organized legal observing program. So I encourage you to look at their program as well if you're interested in a formal training. Okay, so NLG's number is 503-902-5340. They're really well organized in supporting folks who are arrested during protests and whose rights are being abused by law enforcement during protests. So I encourage you to keep that number. You have a right to know why you're being arrested or detained. So you can ask the officer, what crime you're suspected of, or what crime you are being arrested for. And one right that doesn't get talked about much here in Oregon, but is part of Oregon's state constitution, Article 1, Section 16, protects arrested and confined people from unnecessary rigor. So if you are arrested, the way you are treated and the conditions you're subjected to need to be justified by necessity. And I make note of that in this presentation because I think that especially while we also are experiencing a viral pandemic, the COVID-19 pandemic, you have a right to a safe environment. And right now, most jails and all of our state prisons cannot exercise or implement safe practices like physical distancing or social distancing that is being required of us in the community. And so I think that there is a good reason to assert that you have a right not to be held in jail if you aren't a threat to the physical safety of the public. Now, again, is that going to keep you out of jail? Certainly, I doubt it, but it is something that to be mindful of. And if you do find yourself in that situation, to speak with your attorney about. You also, if you find yourself taken to jail, have the right, I would say, during this pandemic to be provided with basic hygiene items, things like protective gear, masks, and a safe and clean environment. Okay, since we're talking about arrest, I wanted to take some time to talk about the crimes we most frequently see folks arrested for in the context of protests. And those two charges are interfering with a peace officer and disorderly conduct in the second degree. So first, interfering with a peace officer. You can find the statute that lays out the elements of this crime at OWLS 162.247. One of the ways that you can commit the crime of interfering with a peace officer is refusing to obey a lawful order. So I think one of the most common orders you might hear while out at a protest is in order to move or in order to disperse. However, if you look at the statute very explicitly exempts passive resistance. And I want to talk about this because often passive resistance at protests, especially when there are crowds the size that we're seeing now, where it's really hard to move when you're told to move, or really hard to get off the street when from wall to wall on a street and sidewalk there is a crowd of people, or really hard to just leave in a matter of minutes when all of downtown Portland is filled with people. Or your car might be in one direction and you're being told to go another direction and you have to figure out how to get back to your car. All of these things, I think, make it create situations where often police are saying to leave and people are standing still. There's a 2017 Supreme Court opinion, Oregon Supreme Court opinion, State v. McNally, that defines what passive resistance means. And I highlight this because I think there's a lot of misinformation about, or frankly, misapplication of the interfering with the peace officer statute in the context of protests. The court said in State v. McNally that passive resistance is nonviolent non-cooperation. And I want to tell you the facts of that case because I think it looks a lot like not moving when a police officer tells you to move, or not dispersing when a police officer tells you to disperse. So in State v. McNally, it involved a person who was at a Greyhound bus station. So not a traditional public forum, in fact. And the person got in an argument with the ticket sales office, and the salesperson said, "You need to leave," called the police came and also told the person, "You need to leave." Started grabbing the person's stuff and walking it outside, and the person refused to leave, saying, "You can't tell me to leave, I'm not going to leave," that kind of exchange. And the Supreme Court said that behavior is entitled to a passive resistance jury instruction. And I'm going to pause on interfering with peace officer and move on to disorderly conduct and then talk about something relevant to both. So disorderly conduct in the second degree. One of the ways that you can commit the crime of disorderly conduct in the second degree is obstructing vehicular pedestrian traffic. Easy to do while in a large crowd, certainly. This is another law, though, that I think is often misapplied in the context of protests. So we submitted, ACLU of Oregon submitted an amicus brief on behalf of Teresa Rayford, who is a Black activist here in Oregon, founder of Don't Shoot Portland, and one of the real leaders in the Black community on police violence in particular, but the general rights and dignity of the Black community here in Oregon. So Teresa was involved in a protest that in honor of Michael Brown's death, where she organized a group. The group was created artwork, then was holding their artwork out in public on the street on Eastern Portland, and they went briefly into an intersection and did a chant in the intersection, then moved back off the road. She was kind of walking up and down a turn lane, kind of leading chants, had her back to the road, but you could see there wasn't heavy traffic, cars were easily going around her. And she had 5 officers, I believe, don't quote me on that number, walk from across the street directly at her, grab her, and take her into custody and charge her with disorderly conduct in the second degree for obstructing vehicular traffic. We submitted an amicus brief in that case to highlight just how much this law was being abused to silence protesters, and in particular, protesters who were protesting against police violence and protesting on behalf of the dignity of Black human life. So a couple of points from that brief that I wanted to share with this group. If you look at the disorderly conduct statute, which is ORS 166.025, I'm actually going to pull it up so I can read some of the language here for you. So the first element of that crime is having the intent to cause public inconvenience, annoyance, or alarm. We argued that this language applies to serious disturbances that threaten to cause injury to the public at large. So if you think about the case I just described to you, Teresa Rayford's case, there was no kind of public at large injury there to the extent any traffic was slowed down. It was a Sunday in a not very busy part of town. Similarly, you know, I would argue now, while many of us are being told to shelter in place, we're not seeing a major injury at large to the public. As far as the obstruction piece goes, so subsection 1D, really, if you look at the legislative history, we would argue that that means rendering the driving or the road or the walkway effectively impassable, not just getting in the way or causing cars to use one lane over another, but really rendering that way, that passageway impassable. And finally, and we Teresa secured a jury instruction on this, folks need to be acting with the specific intent to obstruct the road or the passageway, and a specific intent or with a conscious objective to breach the peace. And what I want to point out about both IPO, so interfering with a peace officer, and disorderly conduct in the second degree is that the legislative history of both of these laws, you can see it in State v. McNally, you can see it highlighted in our amicus brief, which I believe will be up on the website, in the amicus brief from State v. Rayford. The legislative history of these laws make clear that the legislator was not intending to criminalize protesters. In fact, they were very specific, they were very explicit about protecting the right to protest and protecting civil disobedience from their purview. So things like passive resistance, when you see folks refusing to disperse or refusing to move, I think there's a real serious question if that's criminal behavior here in Oregon, but it's very clear that law enforcement thinks that to be true. So I really invite you all to interrogate that for yourselves. And if you happen to find yourself charged with one of these crimes, to really speak with your attorney about that. Reach out to us if you feel like you might want some support, or your attorney might want some support in those two crimes in particular. And I feel like I need to share, just so folks know, you know, sometimes folks are also charged with riot. That's ORS 166.015. So discon and interfering with a peace officer are both misdemeanors. Riot is a Class C felony, where there are 5 or more people engaged in violent and tumultuous conduct, and creating a grave risk of public alarm. All right, while you're protesting, so let's go back to not being arrested, because nobody wants to be arrested. While you're protesting, you have a right not to be subjected to excessive force. What is excessive is what an officer reasonably, or what amount of force is justified, I should say, is what an officer reasonably believes is necessary to protect safety based on a totality of the circumstances. That's really hard thing to judge in the circumstances. But I think I would point you to Portland Police crowd control directive to see at least one clear line, which is when crowds are gathered, weapons should not be indiscriminately deployed into those crowds. I think that's a really bright line that we all should agree on. and for me raises very serious questions about why tear gas and rubber ball flashbang grenades that blow up and shoot several hard rubber bullets into a crowd without being able to control where those go. I think there are serious questions about why those weapons are being used on what is being admitted are largely peaceful crowds. I encourage you to check out organizations like the Oregon Justice Resource Center, who has filed a lawsuit on the use of tear gas, and we've submitted letters and public comments on these types of uses of weapons too. Right now, Portland's crowd control directive is open for comment. If you're interested in making comments on that directive, I would encourage you to do so. Before I close out excessive force, the excessive force section, I also just want folks to be aware of some immunities that law enforcement have. I think these are important to think through, not only when you think about accountability, but how are we looking at our system and seeing where there are barriers to accountability. Those immunities include qualified immunity. I think that is one that's being talked about a lot right now. So when civil rights lawsuits are brought against law enforcement, individual actors enjoy qualified immunity. What's really hard about qualified immunity and why there's such a conversation growing around that particular doctrine is that the Supreme Court and a lot of the case law that has developed around that doctrine almost makes it so that somebody has to have experienced the exact same thing that you have experienced, and the Supreme Court has had to rule that that experience was a violation of that person's constitutional rights before you can hold officers accountable for the same behavior. Which, if you're experiencing something new, like a COVID constitutional violation, it's really hard to imagine somebody having the exact same experience and it getting all the way to the Supreme Court and having a constitutional ruling on that. So it is a very effective barrier to accountability that I think needs to be revisited here in Oregon and across the country. There are also, Oregon tort law also has some immunities. If you're interested in those, they're at OWLS 30.265. That one includes public officers acting to prevent riot, civil commotion, riot or civil commotion. It includes a failure to perform a discretionary function. And believe it or not, we have run into, in some of our protest-related use of force cases, the workers' comp coverage immunity. So those immunities are also available to law enforcement and may come up in the context of use of force at protests. All right, let's talk about observing and documenting at protests. So another disclaimer really quick, I just want to be clear that this particular presentation is not intended to be a legal observer training in full. I hope to just introduce the concept and some basics that I think are important for community members to know. This, having listened to me, does not make one an official ACLU of Oregon legal observer, though I will say that we are organizing a training, if you're interested in becoming an ACLU of Oregon legal observer in Portland or elsewhere. We are holding a training Thursday evening. We're pulling it together pretty quickly, but have a lot of interest right now. So I encourage you to reach out to info@aclu-or.org. if you're interested in finding out more information about our Legal Observer training this week, Thursday evening. That's June 11th. Again, I just want to mention the National Lawyers Guild in Portland also has a really robust program and do a great job. So check them out too. All right, so really quickly, at least I'll speak for the ACLU of Oregon's program. Our purpose out there is really to provide neutral eyes on the way police are responding to protests and document any rights violations that we may see. So all of the things that we've discussed are the types of things that our legal observers are trained to look for and think through and document. Types of information that is good to capture. Name and badge number of officers. We've also unfortunately seen that although policies often require officers to show their name and badge number, we've seen some law enforcement engaged in obscuring their name or their badge number, or you know, covering up that information, or just not having it. So that's also another thing that I would say to document. The more familiar you are with your local law enforcement policies, you may have more ideas about important things to document that violate those policies. Vehicles. So sometimes if actions are coming from vehicles, or you see perhaps something that looks like a military tank, documenting descriptions of the vehicles, vehicle numbers, things like that can be helpful. Taking photographs can be really helpful. Things like weapons that you see officers holding. Often, if for example, a tear gas canister lands on the ground near you, you know, definitely think about your safety first. But if you notice one laying on the ground that is no longer kind of active and irritating you, you can take pictures of those canisters to give either civil rights organizations or the public, frankly, information about what weapons are being deployed by their law enforcement agencies against crowds. And then injuries. Photos of injuries are helpful if you're injured in particular and are looking to vindicate your rights. Taking photos of your injuries, documenting those injuries with through keeping your medical records, any mental health records, things like that are helpful. And then recording the orders that you are hearing from law enforcement, what time those orders are being issued, how much time is passing between orders, if there's an order to disperse, is the order through the sound truck clear, are the directions clear, are people able to comply with those directions. And one caution, if you're filming or taking photos, is at least at ACLU, our purpose is not to catch criminals. Our purpose is not to document people engaged in criminal activity. Our purpose is not to obscure the truth of what's going on either, but we try not to capture individuals' faces to protect their personal privacy while they're out protest. It's not just about criminal behavior either. I think that a lot of folks take risks, especially if they are someone who holds a lot of marginalized identities, or identities that are often targeted by law enforcement, even when they are engaging in lawful behavior. The privacy of those folks at those protests can be really important to protect. So we try not to capture the faces of people who are in crowds. If you are out at a protest and you feel like an experience you had is one that's important to document, we also encourage you to write down a summary of what you experienced as quickly as possible after you experienced it. Yeah, and so To make your life a little easier, if you're wondering how to collect this information and get it to folks like the ACLU of Oregon, I want to just encourage you to check out the ACLU of Oregon's mobile justice app. So this is a phone app, and I don't believe I sent it ahead of time to the OWLS folks. So let me just copy this link real quick and put it in the chat here. And I will send it to all panelists and attendees. So here is a link to the ACLU of Oregon's mobile justice app. And if you're in Oregon, it's important to grab the Oregon app. There are different apps in different states, so that makes sure that it comes to the Oregon affiliate. This application on your phone allows you to record police at protests or otherwise, capture those images or activities that you want to capture, and have it be simultaneously uploading to our server. And that gets reviewed by our legal intake team. And be sure, please, to include your contact information if you'd like us to be reaching out to you. Otherwise, it makes it very hard for us to figure out who sent us the information, and if we have questions about what we're seeing, it may be hard for us to take action in response to the video if we don't have somebody we can follow up and ask questions of. Really quickly, also, I just want to share the ACLU of Oregon's intake contact information in case you're not using the mobile justice app but want to send us something or want to speak with us. The email is intake@aclu-or.org. We also have a web form on our website. So our website's connected to the link that I just shared. And our phone number, intake phone number, is 503-227-3186. So please reach out to us if you think that your rights have been violated. And we either can talk to you about your options or get you helpful resources. Yeah, and thanks for being out there. Lastly, before we open it up for questions, I just want to talk to white folks who may be listening today. I think, you know, there's a lot of energy building right now around Black Lives Matter protests in particular. And some things that I've seen that I want to encourage white folks to think about are why are you showing up? Are you showing up for a photo opportunity or performance? Or are you showing up to be a true ally and supporter of the demands of the Black community at this time? Things to think about while you're out there. Are you listening to organizers, or are you trying to advise folks on how to protest? I strongly encourage you to listen to the organizers and community members who are directly impacted by now on my cell phone. I apologize, everyone. Somehow the power in my entire house clicked off, which clicked my Wi-Fi off. Yeah, are you in the middle of something? Am I coming back in the middle of a discussion?
Oh, no, we were just talking about how we would resolve the pending questions since you weren't here to answer them, but now you're back.
Cool. Yeah, I guess just real quick before moving to questions, I wanted to give a shout out to some organizations to and lift up the work that they're doing. So Don't Shoot Portland, I mentioned Teresa Rayford's case earlier. She's the founder of Don't Shoot Portland, Oregon Justice Resource Center, Rose City Justice, Urban League, Unite Oregon, the Council for American Islamic Relations, the Oregon chapter, Coalition for Communities of Color, Pacific Northwest Family Circle, Portland African American Leadership Forum, Albino Ministerial Alliance, and so many more. Please look up these organizations to educate yourselves about the community's demands right now, and how to get plugged in to supporting the Black community in Oregon.
And so one of the questions that we've got in the chat box right now is just following up to see if, before you got disconnected, if there was anything else that you wanted to share with us about white etiquette at protests and folks not just showing up for a photo op or for the Instagram.
Yeah, I think one thing, so I've been doing my own learning around this too, so I don't purport to be an expert, but as a white woman myself, one thing that I've been hearing and learning is that there has been observation sometimes that for white folks who are maybe new to the protest space and might be uncomfortable with law enforcement around, and knowing that in some locations there is frequent use of force, white folks tend to move toward the center, which leaves Black and brown folks on the outskirts, so closer to law enforcement and closer to that use of force, where we as white folks are less likely to have deadly or excessive force used against us, using our privilege as white folks to stand between Black and brown folks and law enforcement, and offer some protection there. And then just educating ourselves about what the community is organizing around, connecting with organizations who have been doing this work for a long time, doing the work of racial justice for a long time. So those organizations that I just read are organizations I think you could start with. I think also nationally, our national ACLU is connected with the Movement for Black Lives and supporting their efforts. So those are some things that I just wanted to mention. I think the white community has a lot of work to do to get behind this movement and make sure that it doesn't make sure that the demands of the community are being heard and actually acted upon, because they're not new demands. We just have, I think, failed often as a country, failed to act on them. So those are my 2 cents there. And I'm happy to engage with folks more outside of this call on those questions.
So one of the other questions that's currently in the chat box, and 2 of these questions are kind of intertwined, from Kenneth Dills to all panelists, we have, are law students able to attend the legal observer training? If law students are allowed to attend the training, are they able to act as legal observers at protests? And then also we had a follow-up request for additional information on how folks can learn more to attend that ACLU training on Thursday.
Yeah. So the answer to the first question about whether law students can be legal observers, absolutely. There's no requirement to be a lawyer to be a legal observer. So while our legal programs network is strongest in the community of lawyers, and we happen to have a lot of lawyers who are legal observers, you do not need to be a lawyer to be a legal observer. You just need to go through our training. So for the question on the training, I was hoping that we would have a registration form up and ready before this presentation, and unfortunately we don't. But if you email info@aclu-or.org and say you're interested in information about Thursday, June 11 legal observer training, I will talk to the folks in our office who monitor that email and just let them know that this is how we're handling it, and we can get you on the list to get that information as soon as it's ready.
Okay, so another question currently pending in the chat box. This is from Alana Axley. As a graduate preparing for the bar, it's extremely difficult to care about the bar study program when I want to start working in the community. Is there a place in the ACLU where law graduates, not yet barred, can do legal work with the organization?
Yes, though I will say that this work will continue for a long time, and I strongly encourage you to pass the bar and become a lawyer so that you can stay engaged in this work for a long time. And I mean that seriously. I think there's a lot of urgency to act and burn ourselves out. And this work isn't work that needs to be done just in this moment. It really is work that is going to take sustained effort over a long period of time. You know, taking time to study is important, but there is also opportunity. We do have an internship program where we work with law students. I think graduates can fit into that program as well. That same email info at, I think, can be used if you're interested in getting information about that. We also have information about our internship program up on our website. And I think if you're just interested in providing research support at the ACLU of Oregon, getting plugged in with our legal program to do that kind of work might be available as well, just depending on opportunities at any given time.
All right, well, thank you, Kelly. Does anyone else at all have any other questions that they would like to post in the chat box at this time? Or Kelly, do you have any other final parting words for things that folks should consider?
Black Lives Matter.
Well, on that note, thank you, Kelly Simon, Interim Legal Director of ACLU of Oregon. We really appreciate your time today. This has been a fantastic presentation. Thank you.
Thank you so much, Anne.